start things. What would you do in that situation? Would you just create separate entities for each one to keep it simple?
Probably. I probably would. Because you want, and the reason I would do that is because I would want to have the IP clean among the different companies. Equity is just math. I mean, it's pure arithmetic, and you can do whatever you want with the numbers to get appropriate ownership. But IP, you want to keep that clean. Choice of jurisdiction. We put California up there. Don't ever incorporate in California. Always incorporate in Delaware. We always know when somebody has incorporated themselves through LegalZoom or somebody like that, because that's the only time we ever see a company come to us as a California corporation. Investors often, usually, almost always, will make you change your incorporation from California to Delaware. And that will, depending upon at what stage you do that, that will cost you between $10,000 and $50,000 to do. So you may save a couple $100 a year on taxes by being in California. I guarantee you will spend many, many, many thousands of dollars as a result. Partly because you're probably going to have to change, but also because the state of California is ridiculous. The Secretary of State's office, who handles all corporate filings, they are, and I'm being filmed and I don't mind saying it publicly, they make life difficult for startups. They're inconsistent and they're mercurial in how they apply the law and how they assess what the law says about startups. Don't do it. It's just not worth it. So your initial capitalization. Oh yeah, sorry.
Going back to the California versus Delaware thing,
Yeah.
do you still have to pay the California incorporation tax?
You do. If you're here, you have to do what's called qualifying as a foreign corporation. Okay. So you pay and you pay an annual franchise tax to the state of California. So that's the downside of being a Delaware corporation in California is you are paying tax in two different states. I promise you that you will spend much more money by being a California corporation than you will save by being. The only caveat to that is, again, if you're never going to raise a round of financing and you're going to bootstrap and you're going to be the only holder of common, but if that's the case, then you should probably be an LLC anyway.
What are some of the specific benefits that high-level Delaware offers that California states don't?
Yeah.
The corporations even from Delaware, so what is it about Delaware that...
So the classic answer that people give is that Delaware corporate law is well defined. That nearly every, there's very little that comes up new for a privately held corporation that hasn't already been addressed by the Delaware courts. The law is very sophisticated. It's very user friendly, and it's that user friendliness translates down to the Secretary of State's office. They are very customer oriented, and in fact, the state of Delaware this is a huge amount of the state of Delaware's revenue. So they do everything they can to make it as easy as possible to incorporate in Delaware and exist as a Delaware corporation. If you need to file an amendment to your certificate of incorporation and get it back in an hour, yes, it's just a question of how much you want to pay. You can't do that in Delaware, in California rather. California, substantively, they have a lawyer review every filing, and what I've seen happen numerous times in California is one examiner, because you can pre-submit it, and it takes 24 hours for them to do this. You pre-submit it, they say, okay, this is fine, or they have changes. Then okay, great, we're done. Then when it comes time to file it, because you're going to close your financing, or you're going to close your merger, another examiner looks at it and says, yeah, no, I know my colleague said it was okay, but it's not. And in some cases, we're going to say it's not for really substantive reasons, and you have to fix it. And there is no meaningful way to appeal that. You can make phone calls. Delaware doesn't work that way, and so what I will tell you is my IP litigators say that Delaware, from an IP litigation standpoint, Delaware is a bad place to be sued because of the courts and the judges. that it is not as good a place to be a defendant in a patent matter. You know, if you're sued in a patent case, you're probably going to end up in Texas anyway, because that's Eastern District of Texas, Marshall, Texas, and other garden spots.
If you do have patents that you're selling to the company, where is it still Delaware that you want to end up incorporating? Like a substantial patent?
Yeah, that doesn't. So maybe you spend 30 seconds thinking about the patent litigation risk, but that's not going to change your answer. It's going to be, you're going to decide it's California or Delaware based upon the corporate reasons, not because of the IP. The assignment documents will look identical, whether it says California or Delaware. So, structuring your initial capitalization, kind of fundamental defined terms that we talk about. Authorized stock, that's the number that's in your certificate of incorporation. It could be 100, it could be 10 million, it could be 10 billion. If you've got a public company, they have authorized shares of billions or more even. For the purposes of what you guys normally think of in terms of cap table and fully diluted capitalization and percentage ownership of the company, the authorized share number is irrelevant. The authorized share number just tells you legally what you can issue under state corporate law. Issued stock is what you actually have issued. It says that's what's outstanding. That's the number that you worry about. So if you have 10 million shares authorized and you have one share issued, that one share is the 100% owner of the company. If you have two shares issued, one share is 50%. It doesn't matter what the authorized share number is. It's only what the issued share numbers. Issuable stock is now what we're talking about when we're talking about fully diluted capitalization. So issued stock is your issued and outstanding shares. Fully diluted capitalization takes into consideration shares that may be issued in the future. Most common is options or stock pools. So you may have, and we'll go into some examples, you may have shares reserved under your stock pool that are issuable. Those would count as part of your fully diluted capitalization, but not your issued and outstanding capitalization. So it depends upon what you're talking about with the other person on the other side of the phone or the email. Warrants are basically options. They're the right to buy shares at some price at some point in the future. And they're functionally equivalent to options. We call them warrants. Warrants usually get issued to entities. Options usually get issued to people. And there are some tax issues around why options versus warrants. But if you decided, because you were strange, that instead of having a stock option plan and you were issuing options to employees, you decided, I really need to issue warrants to my employees. Okay, fine. We'll call them warrants. I mean, we could call them purple, but they're still the same thing. Any questions on that? Yeah. So, standard capitalization, and we recommend kind of a basic default capitalization structure, and what I usually recommend is 10 million authorized, 4 million goes to the founder group, and then some amount kind of parked aside, whether you create the stock plan at the time of the creation of the company or not. You sort of keep in the back of your mind you've got a piece reserved for employees other than the founder team. And the reason we do this is because lawyers are lazy at math. If we were good at math, we would have gone to med school. So we like a structure that has 4 million to the founders, 2 million to the other employees, because chances are on that structure, when you do your Series A, you're probably going to have, give or take 10%, 4 million shares for your Series A investors, including all of your notes and your early seed investment. And it's probably going to look roughly 40-40-20. So if you start out with this structure, that's probably going to give you a Series A price per share in the roughly $1 a share range. And so everything seems to, it sort of hangs together, and it's never going to be exactly that, obviously, but it hangs together in such a way that you don't have a scenario where you have 1 million shares instead of 10 million shares, and so we're going to issue Series A at $10 a share. Mathematically, it doesn't matter. It's the same. It's just, you're paying a fixed dollar amount for a percentage of the company. But the optics of buying a Series A share at $10 a share instead of $1 a share, people don't like that. It's too foreign to them. They're not comfortable with it. More importantly, actually, is that option pricing gets tied to that also. So if you've got an early stage option, people want to buy their options. Post Series A, they want to buy their options at 20 cents or 25 cents. They don't want to buy it at $2 or $2.50. They don't, especially if you're talking about rank and file employees, they're not going to care. They're not going to understand. They're not going to think about the fact that their percentage ownership is the same and their aggregate exercise price is the same. All they're going to see is, oh my God, I got a $2.50 option. Well, I need to be someplace else where I can get 25-cent options. And I wish I could tell you that was not the case, but that is how people think about it. And I have had companies set up operations in states other than California and locales other than the Bay Area, specifically because they had the ability to play with the numbers, and the workforce was not sufficiently sophisticated to understand that, and so they would grant a fixed number of options, but they had done stock splits to kind of monkey with the sharing. And the sad thing is, it worked. Nobody asked the question. So it doesn't work that way out here. People have been getting options for a long time, and so they're much more sophisticated than that.
So in the example you just gave, you then used up the full 10 million in the Series A. Do you then just increase the authorized number if you're going out to raise more money?
Yeah, and the reality is that when you do the Series A, you're going to amend the certificate of incorporation anyway to create the Series A, and you're going to. In fact, what you'll probably do is you'll create an extra 10 million. So you'll have 20 million shares of common authorized, and then you'll have 3 or 4 million shares of preferred authorized as part of it. So. Really, you only care about it at the first go to kind of set up the overall structure.
Okay. And then one other question. One of the earlier questions was, at what point does it make sense to, incorporate, let's say, and then you mentioned, you may or may not create your stock plan at that time of incorporation. What is the most common format in terms of vesting schedules then? So let's say okay, cool.
That I promise.
Are there any tax implications around the number of authorized shares or the number of issued shares of stock? If I issue more, do I get taxed on those shares?
You personally won't. There's a slight difference from a Delaware franchise tax perspective, but it's 50 or $100.
What percentage of company you usually give to strategic advisors?
It depends. The answer is it depends. What I suggest that people think about, and this is not gospel. This is just kind of my rubric that I suggest people use. Think of your equity in denominations of engineers. And stay with me for this one. Because it is kind of abstract, what does an advisor get, what does an employee get? If you decide that one engineer, rank and file engineer, is worth 1/8%, or 1/4%, or 0.5%, depending upon the stage of the company, you can use that. Every founder here in a place like the Bay Area knows what a rank and file engineer is worth to a development team. You can use that as a constant unit. How much is this advisor going to be, how much value is this advisor going to bring me compared to a rank and file engineer? And then you can use that as a comparison. So if the advisor is a person that's just going to make a couple of phone calls for you, then they're probably worth a lot less than a rank and file engineer will less value than they will provide over a 4-year period. And so maybe you give them a token number of shares, 5 to 10,000 shares, just almost as an honorarium. But if they're really going to get down into the weeds with you, get their hands dirty and do a lot of work and spend a lot of hours with you, maybe they're actually worth the value of 2 engineers, because they're gonna help you refine the business plan. They're gonna help you find money. So that may be worth 2 or even 3 or 4 engineers worth of value. So maybe they get a 0.5% or 3/4 or a full point. Same thing with board directors, outside directors. They usually get 1 or 2% on the basis that they're going to be spending a lot of time and providing a lot of value.